Yes, Mr. Humphreys.
Thank you. I was about to look at three cases, NAP, AXA, BURS. For the straightforward proposition, these cases are analogous to the present situation, or can be described as analogous, and the present situation ought to fit within that category of case, because otherwise it wouldn't appear to be sensible. NAP is in the first core bundle, divider 12. This case is useful because it goes through in a very user-friendly way all the authorities of relevance up to the point in time at which this case was determined. So that at 179F, I don't propose to read all this out really, it's more a question of showing the court where the materials are. At 179F, Lord Justice Hobhouse turns to the authorities and takes them broadly in chronological order. So he deals with Forster, which we've now considered a number of times. Over the page to 180, he turns between E and F to Baker. This concerned the purchase of a house in Margate. What ought to have happened, I'm looking just above G, was that the solicitor should have advised them that the house as a whole should be conveyed into their joint names and then separate long leases to respectively the groups that lived there. Instead, the solicitor simply had the house conveyed into their joint names on a trust for sale, which meant the plaintiff had no security. Over the page, Court of Appeal held that the damage was suffered at the time of the original transaction, not at the later date when the Bodmans decided to enforce the trust for sale. The plaintiffs have said that until the attitude and the intentions of the Bodmans were known, there was no certainty that she would be materially disadvantaged. As at the time of the original transaction, it would be impossible to say what, if any, loss she would suffer. The Court of Appeal rejected this argument. They held that these matters went to the quantum of damages, did not affect the fact that damages, it says damages, it should obviously say damage, was suffered at the earlier date. And again, in the quotation, it says damages were suffered again. That's, it ought to say, whether it says damages or not, I don't know, but it ought to say damage. Then a bit further down, these cases were followed by Moore. This was the broking business case. You need a non-competition covenant. There was one, but they were ineffective. 9 years later, Mr. Fenton, who ought to have been the subject of an effective non-competition policy, set up in competition. And there's nothing the plaintiffs could do. The Court of Appeal, again confirming that each case depended on saying facts and no presumption, held that the claim was time barred because the cause of action accrued at the time of the original execution of the defective covenants. Skip a line or two. The argument was again advanced on behalf of the plaintiffs that no one could know at the outset what the likely future attitude of Mr. Fenton would be. The response of the court, again it's the Court of Appeal, was that the imponderables which future behaviour presented relate to the quantification of damages, not to the existence of a cause of action. The court applied what had been said in Baker. The plaintiffs suffered damage because they did not get what they should have got. And that has echoes in contract, of course, and these cases typically concern contracts as well. The reason they're bringing the claim in negligence is because they fear that they are time barred, which is why they're bringing the claim in negligence. Lord Justice Bingham tested the matter in a way that has been found useful in later cases. The matter may be tested. It's common ground on the assumption that the plaintiff's pleaded case is correct, that the defendants were in breach of contract when they negligently advised and settled documents. Cause of action then arose. Suppose per impossible that the plaintiffs have sued at once and before the later difficulties with Mr. Fenton arose. They would have been bound to succeed. If of the opinion that the plaintiffs have suffered no damage, the judge would have awarded them nominal damages. But it seems to be plain that the judge would not have done that on these facts. He could have assessed as best he could on the available evidence the loss reasonably flowing in the usual course of things from the breach, reaching a figure that might have been large or small but would not have been nominal. And then here's a very important passage. I think that the plaintiffs were in argument inclined to accept that. If, in a contractual claim for negligence, the court would have awarded other than nominal damages, I do not see how it can be said that in an action in tort, based on the same negligence, would have been bound to fail for want of any damage as an essential ingredient of the cause of action. And then he calls that the Bingham test. Bell was advised in relation to a relationship between the husband and wife. Excuse me. What ought to have happened is that the wife executed a trust deed in her husband's favour, and his interest should have been protected by lodging a caution. Failed to do either of those things. 9 years later, the wife sold the house and spent all the proceeds, depriving the plaintiff of his 1/6 share. Court of Appeal held that the action was time barred because the plaintiff's cause of action in tort arose at the time of the original transaction when he did not get what he was entitled to, namely declaration of trust and a caution. The court again stressed that the uncertainty surrounding the future intentions of his wife went only to the quantum of the plaintiff's loss, not to when the plaintiff first suffered damage or the accrual of his cause of action. So pausing there, just to make 2 points very quickly. On the Bingham test, suppose that BDW had sued URS shortly after completion. Let us imagine someone had been examining calculations to consider the application of the calculations in another development, and they identified the mistake. The claim in negligence would be bound to succeed, just as would the claim in contract. It would be obvious that BDW had suffered actionable damage, and it would be entitled to recover the cost of remedial works. In fact, it appears to us that the building professional cases are very often rather easier to determine in that way than many of these cases, involving, as they do, the straightforward situation that defects have given rise to a structure. Defects in design have given rise to a structure which is itself defective. And again, future events in the professional building professional type of case, whether the development collapsed or not, whether the owner's development was sold for full value or not, whether BDW or the owners carried out remedial works or not, all of that goes to quantification of loss. It doesn't go to the accrual of actionable damage. At page 184, there's a summary by Lord Justice Hobhouse of the relevant authorities, and that's at just there at E, F, and G.
Sorry, that's at 18.
That's 184.
Thank you. Yes.
Yeah, E, F, G. And then the disposal of the case of NAP is at 186 G. So may I turn now to AXA, which is in Core Bundle 2, A22. So just very, very briefly on the facts, to save the court the trouble of working them out again. An insurer underwrote an after-the-event insurance scheme for claimants in litigation. The solicitors who had brought along the claimants to the scheme were obliged to vet the claims. It turns out it was the assignee of the insurer who brought claims against the vetting solicitors, alleging negligence in vetting. And there were two types. Negligence at the time of inception by the solicitors, they were called the vetting claims. They failed at the start to say this is a below 50% claim. They said it was higher. And the conduct claims, in other words, when it became apparent during the conduct of the case that the chances had dropped below 50%, again they didn't say so, and those are the two charges of negligence. So the question was whether the causes of action against the vetting solicitors accrued when the policy incepted, or when the claim actually failed, the insured claim actually failed. And in the conduct claims, whether the cause of action accrued when the prospects fell below 50% unremarked, or whether it accrued when the claim failed. So the second half is the same. The later date does your cause of action only accrue when your claim fails. So, in summary, it was held that this case was not a Sefton case. That was the main battleground. The essence of the decision was that the book of business was less valuable as soon as the policies had been underwritten, vetting claims, and as soon as the policy, which had dropped below 50%, hadn't been notified. Whether or not the insured claims ultimately failed or not was irrelevant to actionable damage. It was only relevant to loss. So then, in the present case, this is obviously not a contingent liability case. Damage is suffered as soon as the building is constructed in accordance with a negligent design. The development is defective, that is immediate loss in BDW's hand. So if I take the court just to the relevant passages in AXA. Excuse me, paragraph 7 sets out the decision of the judge, summarises the decision of the judge below, and towards the foot of that page, as such, this case fell within the line of Court of Appeal decisions running from Foster through to Shaw, when the professional's duty is to procure that a transaction has a particular characteristic or feature, and the professional breaches that duty, the cause of action accrues on entering into the flawed transaction cases. Now, pausing there, if I may, it's right that that sort of a case happens to fall into a category of cases that you can label transaction cases. That's not determinative of the underlying principle. The underlying principle is that there has been negligence in the provision of professional services, and then the only question is whether there's been actionable damage. If I can turn to paragraph 30, this is after the court has looked at Sefton. And here Lady Justice Arden says, it follows from the Sefton case that there can be cases like that of Mrs. Foster where a contingent liability is incurred, but it doesn't crystallise into an actual liability until a future date, but where damage occurs for the purposes of the commencement of the limitation period at the time when the transaction is entered into. So that time starts running from that time. And then that's where the label, the damaged asset rule, arises. And then picking up at 31, this is where Lady Justice Arden's analysis leading to the package of rights rule begins. And she explains that by reference to Moore and Bell. And picking it up, if I may, over the page 1677, 6 lines down. In these cases, there was a bilateral transaction under which the claimant should have received certain benefits, but owing to the negligence of his professional advisor did not do so. I will refer to this situation as the package of rights rule. And again, these are extremely useful categories for the nature of case that Lady Justice Arden was discussing. But as I say, they're not determinative of the underlying principle. And there's some element of that stressed by Lady Justice Arden herself in paragraph 32. In my judgment, the damaged asset rule and package of rights rule are best regarded not as a series of independent qualifications on the basic rule in the Sefton case, that the assumption of a contingent liability doesn't cause the limitation period to start to run, but as different cases in which the courts have tried to express a central idea. That idea has to be found by seeking the ultimate ratio in the Sefton case, that is, one which expresses the reason for the decision on which, despite the differences in expression, all the members of the House in that case were agreed. As I see it, the concept on which all the members of the House agreed was that there had to be measurable loss before time began to be run, that is to say, loss which is additional to the incurring of a purely contingent liability. And then, again, that proposition is summarised at paragraph 35. And in the third line of paragraph 35, Lady Justice Arden says, on this basis, what has to be shown is additional loss, and that loss does not have to be of a kind previously considered in the case law. Types of damage considered in the case law thus far include damage to existing property, by damaged asset rule, or a failure to obtain the hoped-for benefits under a bilateral transaction by package of rights rule. So the court's engaged in the metaphysical pursuit of the question of what is actionable damage in the law of tort, which has always been a difficult question. In the present case, in fact, we say, on the fact of our case, it isn't so difficult, but one understands the difficulties that have arisen historically. So the conclusions are beginning in Lady Justice Arden's judgment at paragraph 57, which is on page 1684. And the outcome appears at paragraph 60. 4 lines. It's an integral part of the transaction. He receives a premium which is intended to be retained by him, subject to expenses, to meet that liability if called upon to do so. In economic terms, the premiums are worth less to him. However that may be, he suffers loss in law because the liabilities under the AT policies are greater than they should have been. This is also the view of the judge. And then at 62E, there's discussion of what the additional loss is. The additional loss was the fact that the liabilities under those policies to policyholders were more burdensome, and the package of rights which they acquired under the policies was less valuable than they should have been if the vetting breaches had not occurred. This was measurable loss additional to the incurring of purely contingent liabilities under the policies of insurance. And then the conclusion, paragraph 66C. And then there's just one more passage I'd like to go to, if I may, in the judgment of Lord Justice Longmore. And that is at paragraph 83, which is at 1690. And this is another important point which we place on the lines. So at 83, Lord Justice Longmore reads a draft of what will be Lord Justice Loy's dissenting judgment. And in essence, on this page, he says that he doesn't agree that Sefton applies. And over the page is what we rely on. And this, it's also worth remembering Lord Nichols' observations in the I Credit case. Quote, within the bounds of sense and reasonableness, the policy of the law should be to advance rather than to retard the accrual of a cause of action. This is especially so if the law provides parallel causes of action in contract and tort in respect of the same conduct. The disparity between the time when these parallel causes of action should be smaller rather than greater. In a case where, in any view, the natural cause of action is a breach of contract, the cause should not favour a much later date of accrual for the coexisting action in tort unless they're compelled to do so. So far as that's concerned, inevitably, I say in this case, well, our solution promotes that aim, and a friend's solution, date of knowledge, does not. Finally, then may I turn to co-op and burst. Same bundle, divider 24. Now, we've summarised this case in paragraph 18 of our skeleton. So, again, I'm not going to go through this and read out a great many passages, and I'm quite sure that the court will have read it. So may I then go to, as it were, the highlights, starting at paragraph 16. So, under the heading Principles to be Applied, 16, a claim in tort based on negligence is incomplete without proof of damage. Damage in this sense is an abstract concept of being worse off physically or economically, so that compensation is an appropriate remedy. Skipping, if I may, to paragraph 17, adopting the first usage, there are only two kinds of loss which are recognised as actionable damage, namely physical damage and pure economic loss. not all damage will suffice to complete the cause of action, de minimis non curat lex. In the case of physical injury to personal property, the damage must be beyond what can be regarded as negligible or real damage as distinct from purely minimal damage. 18. Actionable damage is also an abstract concept when what is alleged to have been suffered as pure economic loss. The boundaries of the losses that may amount to actionable damage in pure economic loss cases have been subject to less analysis and are less well defined than in cases of physical damage. And then he discusses Headley Burn. In principle, however, the first question to be addressed in determining issue 1 is what damage was capable of constituting actionable damage in the context of Burse's relationship with his subcontractors. That is a question of law. Inevitably, the submissions of counsel concentrate on the leading authorities on limitation of economic loss cases, and then he turns away from those briefly in order to discuss remoteness, which is of interest, but we needn't go through it for today's purposes. And then to 458, picking up at paragraph 25, if I may, and after having discussed South Australia and NICredit and Lord Hoffman's observations, both judicially and extrajudicially, he says, second line, however, when considering the scope of liability for the consequences of breach, it is relevant on either approach to consider what was the purpose behind the advice given and the expectation of the recipient of that advice, or in other words, what was the risk, and here we echo MBS, what was the risk that should have prompted the putative tortfeasor to take reasonable care. This approach is applicable generally, not merely where it is alleged that the claimant has entered into a specific transaction, and that's the point that I made earlier. It's all part of a bigger whole. And then 26, what then were the purpose and expectation that underlie the subcontractor's duty to exercise reasonable care? What was the risk that a subcontractor should have in mind when undertaking design and inspection services in relation to part of the development that the main contractor is constructing for an employer? Even if the subcontractors had not known the terms of the main contract, they knew that part of Burse's obligations under the main contract had been subcontracted to them, and that Burse's reasonable expectation was that they would provide design or inspection services that were appropriate to the proper discharge of those obligations as required by the terms of their subcontract. Equally, if the designs was defective, the risk was that Burse would build in accordance with it that would have two consequences. First, the building as built would be defective in Burse's hands, would consequently be less valuable because of the need to remedy it in order to bring it up to an acceptable standard. Can I pause there? That's our case 1, as to accrual. And second, the building was handed over to the employer, pause there in our case, sold to owners in its defective condition. Burse was likely to be placed in breach of contract, whether or not it appreciated or accepted it at the time. And then in the middle of paragraph 27, 6 lines up, I conclude that in a case where the development is being constructed for someone other than the main contractor, the primary risk that should be in the contemplation of the parties will be that the main contractor will build and hand over a defective building to the employer and thereby incur liability. Liability usually be measured by reference to the repair costs. Burse accepts that the incurring of liability may give rise to recoverable economic loss as it claims damages amounting to an indemnity against such sums as it has to pay to discharge its liability. It pleads against Jubb and Stewart's, these were the subcontractors, that recoverable loss is not suffered until the loss is ascertained, which in the context of the present issue is presumed to be at some future trial. Did not pursue this line of argument at the hearing, and subject to any authority to the contrary, I consider it to be unprincipled and unacceptable. And then he explains why. These considerations suggest 29 that Burse's cause of action in negligence accrued when Burse incurred actual liability to its employer as a result of the negligent design or inspection. However, Burse submits that this conclusion is precluded by previous decisions of higher authority. And what then follows, essentially, is reliance on Sefton. The judge in this case does not accept that Sefton is in play at all. The liability is not contingent. It's not contingent on a claim. It's not contingent on anything else. And then at paragraph 41, we see that Burse's first submission is that the existence of a purely contingent liability doesn't give rise to the actual damage. That is right, and then he assesses the quality of that submission and rejects it. That then takes him on to an examination of the damaged asset rule, which he summarises at paragraph 44. And in 45, he applies it, and if one looks about 6 lines up again in paragraph 45, to my mind, Burse's interest in the development and in the benefit of its contractual rights are properly to be regarded as assets within the scope of the damaged asset rule. The object of the subcontracts was to provide the necessary design and inspection to ensure that the development as built was satisfactory and Burse's rights were not prejudiced. The assets are capable of being devalued. The devaluation is measurable by reference to the cost of remedying the defects, whether that's undertaken by Burse or the employer. Wardley and Sefton are clearly distinguishable on their facts. And then over the page in relation to the damaged asset rule, if I can look 4 lines down, in the present case there was a present liability which arose at the latest on practical completion. Burse had suffered measurable financial detriment before then on construing the development in accordance with the defective design or as allowed by the negligent inspection. In my judgment, therefore, the requirements of the damaged asset rule were satisfied and time began to run by practical completion at the latest. He then turns to the package of rights rule, noting in the last 2 lines of 48 that it is not clear, at least to him, why it should be necessary in the claimant's disappointment should be in an asset which he acquires. In other words, the claimant's disappointment in relation to the professional services which he is in receipt of could be in relation to an asset which he already owns. Again, that's part of the bigger picture in which these types of cases are analysed. And then, if I may turn through, please, to paragraph 53, which is on page 467. The Court of Appeal in AXA did not suggest that the damaged asset rule and the package of rights rule were mutually exclusive, nor was it attempting to provide a rigid codification of the circumstances in which actual damage should be held to have occurred. I conclude that the present case is within the package of rights rule, because when Burse transferred the defective development to the employer, pausing there, our secondary case, its legal position changed to its financial detriment as it became a contract breaker whose rights under the main contract were devalued by its liability to the employer. In my case, my rights in my sale contracts were devalued by my liability to the owners, and my exposure to liability under the Defective Premises Act, which is a inevitable consequence of a contract of sale of a dwelling, were also devalued by my liability to owners. Finally, in this case, if I may, paragraph 57, it follows that I reject the suggestion that notification of co-op's claim was a material event. Once again, notification was not an event that altered Burse's legal position in any way. This is not a case like Wardley or Sefton, where notification was a prerequisite to actual as opposed to purely contingent liability. It also follows that I respectfully question the correctness of the obiter dictum of Mr. Justice Aikenhead at paragraph 113 of the Linklaters case. I am not persuaded to follow for the reasons set out above. So, having now looked at those cases, I'm sorry if that took a little time.
Mr. Hargreaves, if you're leaving Coulson, can I ask you a question?
Please.
In relation to paragraph 46,
Yes.
the sentence that you read to us in the present case,
Yes.
Ms. Parkin's submission is that that was wrong because of Pirelli. Do you have any comment about that?
That's not right, because there's no question of physical damage in relation to a situation where what one is examining is the liability of Burse in relation to co-op. recognise that Lord, can I just have a think about that and come back to that?
Of course. It was, I mean, obviously, Pirelli and questions of physical damage simply didn't arise, as far as I can see, in the arguments or in the judge's judgment. But that was a submission that Ms. Parkin made yesterday, so I think for completeness, we need to address that.
Yes, of course. Okay. Now, well, it may be that the answer comes, but if I can summarise the analysis of those three cases and that group of cases. First of all, Mr. Justice Stuart Smith observed that there are two kinds of loss that can be regarded as actionable damage in negligence, namely physical damage and pure economic loss. Since Murphy, in those building cases where what has been constructed is itself defective, or put another way, the damage is to the thing itself, then that damage has been recognised as economic loss. Once Murphy is recognised as having ushered in the construction professionals to sit with the other professionals, it would be surprising if the rules between the two remained inconsistent. Foster, AXA, Knapp and other cases are all professional negligence cases. They've been decided on the same principle: as soon as there's more than a minimal loss, a cause of action in negligence accrues. There's no reason why the same analysis should not apply here. No transaction is needed. The transaction cases are part of the bigger picture. The learned judge agreed with this proposition, and he was comforted that his conclusion as to accrual in the case of negligent designer accorded with the position of the other professional services cases, and we respectfully invite this court to arrive at the same conclusion. We also say that there is this further point that all of these cases are in the end derived from a contract, or in almost all of those cases. The liability is concurrent and coextensive, and we refer to the passage I cited from NICredit, that the policy of the law should be to advance rather than retard the accrual of the cause of action. This is another reason we say for arriving at the same conclusion as the judge, and deciding that the damage occurred at completion. Now, of course, there remains this isolated island of legal territory where, in certain very specific and defined facts, where negligence causes a defect and then the defect manifests itself physically in cracking, then it is true that courts presented with what they have regarded as facts on all fours with the facts of Pirelli, that they have not followed the logic of AXA, Knapp and so on. But that is because they have considered themselves to be constrained by Pirelli. And that explains the outcome of Abbott, Ketterman, which is not a case that we've gone to, but is in the bundle, and London and Harris. And in all of those cases, the courts have held themselves to be on all fours or indistinguishable from Pirelli. And I just wonder if I could give the references to where they say that. In Abbott, which is core 18, the references at 8 and 19, paragraphs 8 and 19. Ketterman, which is core 7, the analysis is at 205 F and G. That point is made at F and G, and at 208 G. And in Harris, the point of the case being indistinguishable from Pirelli is made at 22E and 23J. So that's the. I've been to those cases. I've summarised what I consider to be what we submit as the position. I'll come back to my Lord Justice's question later. I need to pick up one or two points, but by no means all the points in my learned friend's skeleton. So could I invite the court to turn, please, to URS's skeleton. So paragraph 26, first of all, please. So again, one reads paragraph 26, page 13. This is a part of Learned Friend's skeleton where she's categorising things. It says taxonomic exercise. But we say it's important not to get distracted by taxonomic exercise. It seems that URS is seeking to place cases in to a subclass where the claimant suffers loss because of entering into a transaction or a flawed transaction, or wouldn't have entered into a transaction at all. But as I've said, those cases are just part of the bigger picture. The other point I wanted to pick up, please, if I may, is paragraph 30, where my learned friend says that the judge failed to identify the type of damage sustained by BDW. That's not at all right and not fair. The judge addressed the question at these paragraphs 48, 49, 59 and 60. Now, paragraph 31, considering first the question of whether BDW suffered economic loss constituting damage to any proprietary interest in the developments, in other words, corresponding to our primary case. Paragraph 31A, it said that the learned judge wrongly elided the concept of a latent defect with that of damage. The learned friend refers to 87 and 113, thereby making findings which were contrary to Pirelli and Ketterman, in which the House of Lords held that the fact that a building suffers from latent defect is not enough to constitute actionable damage at law. Now, as far as that's concerned, we submit that it isn't as simple as that. In Pirelli, if we can turn it up, that's the first core bundle at divider 4. The relevant passage that the learned friend relies on is at F and G. I think with all respect to
Page.
F and G.
I'm terribly sorry, page 16.
Thank you.
I think with all respect to Lord Justice Geoffrey Lane, there is an element of confusion between damage to the plaintiff's body and latent defect in the foundations of a building. Unless the defect is very gross, it may never lead to any damage at all. It would be analogous to a predisposition or natural weakness in the human body, which may never develop into disease or injury. The plaintiff's cause of action will not accrue until damage occurs, which will commonly consist of cracks coming into existence as a result of the defect, even though the cracks or the defect may be undiscovered and undiscoverable. And in Ketterman, which is behind divider 7 in this bundle, the relevant passage is at 205F. And here Lord Key said, at page 16, he expressed the opinion that a latent defect in the building does not give rise to a cause of action until damage occurs. In the present case, there can be no doubt that the defects in the house were latent. No one knew of their existence and damage occurred in the summer of '76. This branch of the argument for the architects is, in my opinion, inconsistent with the decision in Pirelli. It must be rejected. Now, in each of these cases, it's important to recognise two things. First, that Lords Fraser and Keith, respectively, consider that physical damage is required before a cause of action can accrue. And secondly, in each case, there was subsequent physical damage in the form of cracking. But the point of my learned friend skeleton at 31A doesn't run because the present case is different. Not only has Murphy now been decided to categorise the damage as economic loss, but subsequent physical damage has not occurred either. And neither of those two cases decides what the situation is under what one might describe as the Pirelli rule, where there has been no subsequent physical damage. And then that leads me back to New Islington or first principles. Well, just one brief word on doomed from the start, which will involve opening Pirelli again. Core 1, divider 4. Obviously, it's right to say that this didn't gain a great deal of traction, but in the authorities that followed. But my learned friend is wrong to say that this was not a finding available to the judge, because what happened was he raised the question at the end of trial, invited notes from both parties on the question, received notes from both parties on the question, or at least from me, and both parties were very neutral about the issue for reasons that are understandable. But what we said in our submission was, if this case now, with all of the water that has gone under the bridge, and for what it is worth, which is very little, it is that this is a doom from the start case, then, quote, so be it, unquote, is what we said. So, having invited submissions and having received them, it was entirely open to him to make a finding on doom from the start. And my Lord, in answer to my Lord Justice Coulson's question, what one can say this much about doom from the start. The relevant passage is at 16H of the judgment. And it's clear, we say from that passage, that Lord Fraser obviously had some residual concerns about the determination that he was arriving at in Pirelli. And I think that we submit some glimmering that he hadn't covered all of the potential variables. In particular, perhaps, on speculating, but in particular where a gross defect, that's the language he uses, never causes damage, but is discovered. In that case, there never is physical damage, and so how does Pirelli fit with it? Because Lord Fraser is under the impression that commonly cracks come into existence. But where that doesn't happen, how does Pirelli fit? So what we would say is it is at least notable that in that example, he accepts that the owner's cause of action would arise as soon as it was built. So I don't know how much that point is worth, but it's worth taking into account. It's worth observing it.
I think, am I right in thinking that after Kettleman, doomed from the start doesn't really feature again in the authorities?
Well, I can't be absolutely certain of that, but certainly it's right to say that doomed from the start has disappeared from the state.
Yes. But there's no post-Murphy, i.e. its economic loss case, either way, on whether an inherent defect is makes the building doomed from the start.
Well, we have to take a look at that, which we can certainly do.
Well,
we won't come with files and files.
No. I don't think the court is inviting that. But that is that would be my current understanding, because effectively, because of how it was dealt with in Kettleman.
Yeah.
Doomed from the start was not a popular runner.
Well, that's the end of section 2 by submissions, if the court still recalls where they are, but this may help. Section 3 is the secondary and tertiary cases, so I can deal with, I hope, reasonably quickly.
Just before, well, as you leave, as you wave goodbye to your primary case,
Yes.
can I ask you this? I hope it's not an unfair question, but I shall ask it anyway. Mr. Justice Fraser pointed out in his judgment, rightly I think, that one of the oddities of this case is that you, the employer, were going for the earliest possible accrual date, and Miss Parkin, the engineer, was going for the latest possible accrual date if there was a cause of action. I understand her cases there wasn't, but if there was a cause of action. That's the wrong way round in the world in which I used to inhabit. So the question really is why? Yes. I suppose one answer is you could say, well, my lord, that's the law. And I would understand that. But can I ask the question anyway?
Of course, of course. It's paradoxical on my learned friend's side because the later she has the date running, the better my position on limitation. And it's paradoxical on my side for the same reason. But we have, the answer is what your lordship has offered me. That is the law. The last thing we want is to argue for our tertiary case as our primary case because we consider that our primary case is right in law.
Right. Well, I suspected that might be, but
The tertiary case would suit me an awful lot better.
Well, I understand that. I understand that.
So
yeah, okay. That
at least was a question I was ready for.
Yeah.
I've got a note on the other one somewhere. I'll come back to it.
So secondary and tertiary cases.
Yes. So far as the secondary case is concerned, that's going to unfold, but quite quickly, I hope, in 4 parts. Part 1, accrual by incurring liabilities. Verse. Part 2, not a Sefton case. Part 3, if a Sefton case, still accrual. Part 4, responsive.
Sorry, part 4.
Responsive. So, part 1, accrual by incurring liabilities. My ladies, my lord, we've already looked at verse. The point is short. If it's to be assumed BDW's primary case is wrong, then verse is directly on point for BDW's secondary case. The cause of action accrued once third parties acquired interests in the dwellings under contract. BDW had an immediate and immediately enforceable liability to owners in contract and under the DPA. And both of those, not merely the contract liability, the DPA liability was an incident of that contractual transaction, as your lordship, as my Lord Augustus Coulson pointed out in argument. So that fits within the damaged asset and package of rights descriptions. We rely on verse. We also rely on another case, which I would like to take the court to, called Hank Dyers. it's been a while since I've incurred a penalty, but this decision is in folder A4. But it's a good illustration of another case in which a court had no difficulty deciding that Sefton was inapplicable, which followed Burse, and which found that Linklaters was distinguishable, well, wasn't to be followed. So it's A4 behind divider. Forgive me, I've got wrong reference. It's behind divider 36A.
Interface.
Yes, interface.
Yes.
Yeah. So, try and explain this straightforwardly. We have a chain, if I can call it that, descending from the top. So, at the very top, there is a bank in Switzerland that would like to have some agreeable carpet tiles fitted to its premises. Below that, there is Interface. They manufacture carpet tiles. Below them is Premier, and they are dyers of yarn. And then below them is Airedale, who make dyes. So it's a fairly straightforward chain in that way. What happened is that when the tiles were installed and after they'd been exposed to sunlight, they instead of being a rather nice grey colour, they became green because red had given up the ghost and blue and yellow were remaining in the ascendant and ended up being green. So what happened here is that at Premier, the
They
dyers...
actually were exhibiting an off-tonal fade,
very much.
according to paragraph 15.
That's right, that's right. So this is all very unfortunate, and the Swiss bankers were most unimpressed. But the terms were reached, Premier settled, and then Premier, penultimate in the chain, sued Airedale at the end of the chain in relation to their dyes. They sued first in contract and applied to amend to plead in negligence. Premier said that the negligence, cause of action in negligence accrued, bless you lady, when the tile sustained damage by fading in the sun, as one can now begin to predict, and until then the damage was contingent. Airedale said the cause of action accrued when Premier acted upon A's advice in relation to dye, or the failure to advise in relation to dye, or when the dye was first used to dye the yarn, or when the carpets were fitted. So they had those various cases. And if I can start just by, I'll run through it now with that introduction quite quickly. Paragraph 26, this is His Honour Judge Safman, sitting as Judge of the High Court in Leeds. You can almost imagine the sigh at paragraph 26. He says, inevitably the starting point as to whether a cause of action is statute barred is the date when the cause of action accrued. And then Premier contend that the cause of action against Airedale accrued when the sunlight caused a reaction, so it was only when it sustained damage. If that's the case, and the new claim is well within the limitation period. Airedale, however, argue if there's a claim in negligence which is denied, it arose either in June 07 when they acted upon omission or commission and formulated a bad dye recipe, alternatively when the dye was used, alternatively when the carpet was fitted. Certain principles of law have been agreed, paragraph 30. Paragraph 31, the dispute centres on when Premier suffered actionable measurable loss. The case was that it was contingent until 2010. Now, at paragraph 32, there begins a detailed discussion of Sefton, which I'm not going to trouble the court with. We can pick this up again at 65. The court having decided that Sefton was a non-runner in this case. At 65, there's the by now familiar course running through Forster, Moore and other cases. Over the page, please, at 72. Let me now turn to Co-op and Burse, and then the judge helpfully summarises that. and goes carefully through the judgment of Mr. Justice Stuart Smith as he then was. Paragraph 83, in having looked at that, what asks Mr. Toms is the difference between the situation with which I am concerned and the situation which prevailed in Burse. Mr. Doherty marshals 4 arguments, so in fact there are 3. First, that it's factually different and distinguishable. He says Interface suffered no damage from the yarn because it sold them in the form of carpet tiles down the chain. It made no loss on the sale. Interface's only claim against Premier would have been for nominal damages. That's not true damages. In other words, the supply chain was considerably longer than that in Burse, and that results in Premier, unlike Burse, having no direct liability to the end user. Over the page 86, it has to be said I'm not attracted by that argument. There is indeed a longer supply chain than there was in Burse. The fact is that on the analysis of Mr. Justice Stuart Smith, Premier's financial position changed as soon as it became a contract breaker, as it did when it supplied dyed yarn that did not meet the necessary colour fastness level. The loss to Premier's package of rights was not dependent on the length of the supply chain. Its package of rights was devalued when it incurred a liability to its customer, Interface, because Interface became exposed to a claim when it passed on the defective yarn, which claim would be passed immediately up the chain to Premier. His second point is that Burse is not binding. Well, the judge regards it as persuasive. His third point is it's inconsistent with the decision of Mr. Justice Aikenhead in Linklaters. Then he goes through the facts of Linklaters briefly. That was a chain: Linklaters, McAlpine, Howe and Southern. And 93, he says that Mr. Justice Stuart Smith was referred to Linklaters' case, and in particular at paragraph 113. At 57, he questions the correctness of what he describes as the obiter dictum and was not persuaded to follow it. And then conclusions, please. This is there is no page numbers. Paragraph 97. I concluded that Premier's cause of action against Airedale accrued at the latest when Premier supplied dyed yarn to Interface, not simply when the carpet tiles changed colour. I see no meaningful distinction between facts of this case and those cases referred to by Lord Justice Savile in First National. In this case, notwithstanding the length of the chain of supply, 99, at the very least, the package of rights that Premier had against Interface on the supply of the yarn was diminished by its liability to Interface as a contract breaker. Damaged asset rule is also engaged. I've no doubt that, like Burse, it's a case of an accrued liability that immediately affects the value of a contract. In this case, as soon as Premier supplies Interface with unsatisfactory goods, the accrued liability immediately affects the value of Premier's rights under its contract. And finally then, 108 and 109, there seems to be no way of reconciling Burse and Linklaters. Indeed, Mr. Justice Stuart Smith did not seem to suggest one. He simply thought that the view of Mr. Justice Aikenhead was questionable. I prefer to follow Burse because I do not see it as inconsistent with Sefton, but merely as an example of the kind of case to which Sefton does not apply by the court in Sefton's own lights. As for Abbott, this was a case, we've already discussed Abbott, but the judge here makes the same sorts of observations as I have made in the context of my earlier submissions. So, back to where we were: accrual by incurring liabilities on sale, Burse applies, Hank Dyers is supportive, Linklaters should be not followed for the reasons given by Mr. Justice Stuart Smith and by the judge in Hank Dyers. And then note 2 things, and I know this is beginning to be repetitive, but these submissions do fall into place each time. The cause of action accrues regardless that the fact that the existence of the underlying defects was unknown. Knapp, Moore and Foster, that's always the case. And the cause of action accrues regardless of the fact that the loss may be avoided. So that's part 1. Part 2 will be very short. Part 2 is, this is not a Sefton case. Can we go to Sefton, please? Core Bundle 1, Divider 19. I can make good the submission that the present case is not a Sefton case simply by looking at how liability arose in the Sefton case, and that's by understanding the scheme which is described in paragraph 3. In paragraph 3, Lord Hoffman explains the scheme, and he says, by section 36 of the Solicitors Act 1974, the society is required to maintain and administer a compensation fund for the purposes of making grants for, among other things, the relief of loss caused by dishonesty on the part of a solicitor. The society has power to make rules about the fund, and the Solicitors' Rules 95 contain guidelines which will explain the circumstances in which grants will ordinarily be made. General Principle A says the basic object of the fund is to replace clients' money misappropriated by a solicitor. General Principle B emphasises that grants are wholly at the discretion of the council and that no person has a right to a grant enforceable at law, but that the intention of the council is to seek to administer the fund in an even-handed and consistent manner. Claims must be made in a form prescribed by the society and delivered to the society within 6 months after the loss has come to the knowledge of the applicant, Rule 6. So there are two observations to be made. There's nothing guaranteed under the fund, that's the first point. But secondly, no liability can ever begin to arise until a claim in the proper form is made. So that's why this is a truly contingent loss case. And all of the other cases that we've looked at, including our own, is self-evidently and obviously not a contingent liability case. And that's the conclusion that Mr. Justice Fraser arrived at, and he was right to do so. So part 3, even if a Sefton case, there is still accrual. Now the way we put that, it begins to shade into the tertiary case, but let me make the point anyway. Well, what we're saying is that having satisfied our liabilities to owners by carrying out the remedial works must be sufficient for the accrual of a cause of action, even if the liability was contingent. That may not logically entirely work, but I'm sure that the bench sees where I'm going with it. It must be of some significance and of some relevance that to the extent that my client were exposed to liabilities under the contracts and under the Defective Premises Act, we've satisfied them, we've discharged them by carrying out the remedial works.
So it's akin to making the claim under the compensation fund.
Yes.
I mean, assuming any of this applies.
Yes, exactly. It's more that. Yes, exactly. Now, just a couple of responsive points. Picking up, please, if I may, paragraph 32E of the offence skeleton. This is page 19. It's 32E1. You have to go back a page to find the beginning of the originating paragraph. The E1, well, co-op was wrongly decided, and Linklaters was to be preferred. So we don't agree with that. Co-op conflated the concept of risk of harm with the occurrence of actionable damage, and ignored the latent nature of design defects in the buildings, the factual implications of this for any type of negligence claim based on the presence of design defects in buildings. Well, we say that there wasn't any such conflation, and the fact that property might be sold at full value makes no difference to the accrual of a cause of action where damage is a liability. So in that respect, the proposition at E1 is simply wrong as regards the type of liability that we're dealing with. And in E2, the cross-reference to paragraph 24D and the cases referred to that's meant to be a cross-reference to paragraph 25D, and the cases are Murphy, Invercargill, Abbott, and so on. We've already dealt with those. There's said to be an inconsistency or a difficulty in footnote 53, an odd state of affairs in which a building owner has a cause of action who discovers a design defect, sues his design and build contractor, will not have a cause of action until he discovered the defect, but the design and build contractor's claim against his professional consultant would accrue at a much earlier date. Respectfully, we disagree with that. The causes of action in negligence will accrue at the same time. The building owner who discovers the design defect and sues his design and build contractor, the cause of action accrues when the design is incorporated into the construction, unless it's a Pirelli case. The design and build contractor's claim against the designer, cause of action accrues when the defective design is incorporated into the construction. So far as the tertiary case is concerned, we've in effect made our submissions on those already. If we're wrong about primary and we're wrong about secondary, we must be right about tertiary because the loss is within the scope of duty. Now, that brings me to an end of my submissions on the appeal from Mr. Justice Fraser. However, with the court's permission, I would like to just check my notes and check behind that I haven't overlooked any points. So just may I have a few moments, please?
Of course.
Yes, there was just one further point. My own friend yesterday took some pains to take the court to the terms of the engineer's appointment to look at warranties, limitations, liability, insurance provisions, and so on. And it was unclear, respectfully, what the submission was, but it appeared to be an argument that since any person to whom the development would have been sold, transferred, would have had a claim under a warranty, assuming that those provisions had been followed and the warranties were executed and so on, that it appeared to be that somehow BDW would lose its duties, it would lose the benefit of its duties. Well, we say that's of course not right. That is to make, those clauses are to make provision for other parties also to have rights against BDW, against URS. They're not designed to take away the rights that BDW already had against URS. It's an elementary submission.
If I could just say, Mr. Hockley, that's not quite how I understood it, and it just probably doesn't matter, but I thought I'd say that so that if there's something else you want to say. I thought that it was, those submissions were probably directed to the bigger picture policy, and that we needn't worry ourselves about all these individuals whose blocks of flats might collapse, because in any event they had, by all these mechanisms, or ought to have had, redress.
Yes. Well, thank you, lady. Well, if that's that actually raises one of the points really at the heart of this case. I mean, one doesn't want to make too much of the position of the people that live in these blocks, but something does need to be said about the position of those people. And respectfully, we would say that the sorts of people who live in these blocks, ordinary people up and down the country who buy flats, don't expect to find themselves in a position where they have to assemble and raise vast sums of money in order to go about suing the jumbo corporations such as Acon and others who stand by their designs and say there's nothing wrong with them and so on. I mean, I'll make this submission in due course when it comes to the Defective Premises Act and indeed to the Contribution Act. But it is, strictly speaking, in law right that they may have their remedies in relation to the position they find themselves in. But it's another thing altogether, practically, to enforce those rights. And therefore it makes sense, in this case, that BDW, the developer, best placed to stick up for the people who live in the apartments, best placed to shoulder the burden of financing proceedings and so on. It's best that those parties in the position of BDW continue to enjoy that position, whether that's in their rights. Nothing happens to their rights when they transfer ownership. That's why they should be owed a duty under the Defective Premises Act. And that's why they ought to have rights under the Contribution Act. But I'll come and make those submissions in due course when we get there. So unless there are any questions in relation to the negligence appeal.
No, that's very comprehensive, thank you.
I haven't forgotten my Lord Justice Coulson's question. I'll come back to that in due course. Okay. So can I come on to the Defective Premises Act amendments, Contribution Act amendments and negligence amendments. I'll deal with those in 4 sections. Section 1 DPA, Section 2 Contribution Act, Section 3 Negligence, Section 4 Strikeout. And can I just set the scene by taking the court to the grounds of appeal and the respondent's notice. So the grounds are in the core bundle of papers, divider 2, paragraph 30, page 33. So the grounds are to be found in page 33, paragraph 5 little 1 and 5 little 2. 5 little 1, BDW was not owed a duty under section 1 of the DPA, and BDW could not establish that it had suffered a relevant loss. So my submissions in relation to the DPA fall into 7 parts. Please don't be dismayed by the number. I'm hoping to go through them relatively quickly.
Are we going to that now?
Yes.
Right, fine. So my heading is DPA.
Yeah.
And then underneath that, 7 points, which you'll tell us in outline, so I can keep you to them when you make your submissions.
Exactly.
So 1.
1, interpretation of statutes. 2, construction of section 11A. 3, mischief. 4, BDW not a purchaser of a dwelling. 5, no loss. 6, contractual limitation clauses. 7, claim time barred and BSA. Now the court might find it helpful to have open the 2 skeletons. Not that I'm going to keep laboriously going backwards and forwards to them, but then the court will be able to follow the sequence of arguments. And what I can do is I can give the respective references as well.
Okay.
So part 1, interpretation of statutes. This is in our skeleton at 76 to 79. Can I go first to Benyon, please, which is in G. and in G, please divide 2. And within divider 2, please page 407. And we're looking at section 11.4, presumption in favour of grammatical meaning. There is a presumption that the grammatical meaning of an enactment is the meaning that was intended by the legislator. And then under comment, second paragraph, the initial presumption is in favour of the grammatical meaning since the legislator has taken to mean what it says. The presumption is of very long standing, being embodied in the early maxims of the law. And there's reference to Broome. This presumption in favour of the grammatical interpretation is stated by Lord Selborne in the words, there is always some presumption in favour of the more simple and literal interpretation of the words of the statute. More recently, Lord Simon said similar things. Judges of the present day over the page show no inclination to abandon the presumption. And under the heading weight to be attached to grammatical meaning, at least of acts produced since the end of the 19th century, is to be treated as preeminent. In general, the weight to be attached to grammatical meaning is far greater than applies to any other interpretative criterion. The grammatical meaning may be overborne by other factors, but they must be powerful indeed to achieve this. So the short point we make here is that there are lots of different rules of interpretation, but supreme among them is the language of the statute. That's the starting point, and the presumption is that the grammatical meaning is the meaning intended. Part 2. This is the construction of section 11A. So if I could ask the court to open the Defective Premises Act. It's in the second core bundle of C1. Can we just read the relevant sections through first, so that we set the scene? So it's core bundle C1, I think divided 2.
Sorry.
Or C1.
C1, I think it is.
In bundle 2, that's right.
Yeah.
So, a person taking on work for or in connection with the provision of a dwelling owes a duty, A, if the dwelling is provided to the order of any person to that person, and B, without prejudice to paragraph A above, to every person who acquires an interest, whether legal or equitable, in the dwelling, to see that the work which he takes on is done in a workmanlike, or as the case may be, professional manner, with proper materials, and so that as regards that work, the dwelling will be fit for habitation when completed. And then can we look at section 1.4, a person who, in the course of a business which consists of or includes providing or arranging for the provision of dwellings or installations in dwellings, ... arranges for another to take on work for or in connection with the provision of a dwelling, shall be treated for the purposes of this section as included among the persons who have taken on the work. So we make 4 very short points about the construction of section 11A. URS's case is that a purchaser of a dwelling falls within section 11A. That can only be because URS agrees that a purchaser can be a person to whose order a dwelling is provided. Since a developer is also a person to whose order a dwelling is provided, the developer comes within this subsection. So let's take a simple example. A private person owns some land and orders the provision of a dwelling. Here, BDW owns some land and orders the provision of several dwellings. There can be no distinction between the two. That's the first point. The second point is...
It's quite a quaint idea these days, isn't it? That an individual pops down the road, says, look, I've got a plot of land, and asks the local builder to build him a house. The Law Commission report is quite redolent of that, as if that's a common occurrence. Perhaps in 1972 it was, but it isn't now. properties are built by builders or developers.
Usually.
Vast majority.
Vast majority. No, I agree.
So anyway, you say a dwelling provided to the order of any person. You say that must include BDW.
So, second point, if Parliament had intended that subsection A would apply only to purchasers, then that would be redundant, because purchasers would be owed the duty under B. So it must be the case that A is a bit wider than applying to purchasers. And of course, when one looks at A, it doesn't say anything about purchasers. It says where a dwelling is provided to the order of a person. There's another conundrum on the learned friend's construction, and this is the third point, that if a developer develops, let us say, bare land or a factory, previously commercial, and has dwellings built to his order, then inevitably he acquires an interest in the dwellings thereby created, because it's his land and he's had the dwellings built on them. And that brings him within B. So then rhetorically one asks, well, is the developer to be excluded from B because of the operation of subsection 1.4? And if so, how? If he's not to be excluded from B, so that he is owed a duty under B by his engineer, or whoever it would be, then where's the sense in that? Is it that a developer who retains his freehold is owed a duty under B, but the developer who parts with it is not owed a duty? Submit that there's no sense in those sorts of distinctions, or those sorts of logical conundrums. And there's another point which is of relevance to the current crisis in relation to fire safety defects and cladding defects and so on. What if the situation with the development is so serious that a developer buys back the development? That is an option which is being taken up by some of the more responsible developers as a response. They buy back for proper value the flats and the whole block, and release the unfortunate people who live there, and then they do what they do with the land. Now, in that situation, the developer has obviously acquired an interest in the dwelling for the purposes of subsection B. Again, is he to be excluded from section 1 by section 1.4 because he developed it originally? Obviously not, of course not. And so, all in all, one comes to the conclusion on the plain words that there's absolutely no reason whatsoever on the language to arrive at a conclusion that you cannot be owed as well as owing a duty. Now, there was a point made by a learned friend, I think this morning, in relation to this. My learned friend says, under A, well, URS wasn't providing a dwelling to BDW because it was just a services contract. But that's not a correct analysis of the language of this part of the Act. Section 1 tells you who is owed a duty. A duty is owed where a dwelling is provided to the order of a person, and a duty is owed to every person who acquires an interest in the dwelling. BDW falls within section A because the dwelling was provided to its order, regardless of the contract with the URS. Then you look at who owes the duty to BDW, and that is a person who does something with a much wider formulation than the whole of providing a dwelling. Instead, the formulation is a person taking on work for or in connection with the provision of a dwelling. So it makes no difference that URS was not, as it were, a turnkey provider of the development, because its services were work for or in connection with the provision of a dwelling. So those are the plain words. Now, the argument is that you can't at the same time both owe a duty and be owed a duty. In answer to that, we say, well, why not? Why shouldn't you be? And we've developed this in our skeleton, paragraphs 83 to 84 and 99 to 101. I'll come to those in a minute. But first, we go to a case called Heronsley, which is in C5 at, yes, it's in section C of the main authorities bond, behind divider 5. And this is a very short.
Not the core.
It's not in the core. No, I don't know how many penalties I'm up to. But it's quite a lot. I'm afraid.
Well, I think this is a shared one because although we didn't go to it, Ms. Parkin expressly referred to it and relied on it, and certainly speaking for myself. Yeah.
One moment. So, to identify the point at issue, an learned friend says that subsection 1.4 means that because the person who gets somebody else to carry out the work and therefore can't fall within the description of somebody taking on work for the purposes of subsection 1 is treated by the Act as being included within the persons in subsection 1. She says that indicates that means they can only be in the category of persons who owe the duty. They cannot be in the category of those who are owed the duty, and we say that's non sequitur and not rational on the language of the Act. And that is simply because there is only one purpose of subsection 4, which is simply to make clear that you don't escape by the fact that you get other people to do the dirty work and get muddy boots in building the dwellings, because you're treated as, where you're a developer, you're treated as having taken on the work yourself, if that's what you do. But that's the only purpose of that section. If it was intended to have the effect that it excluded you from being owed a duty under subsection 1, then it would have gone about it in an entirely different way and would have said so. And I go to a case called Heronsley, which is in C at divider 5, just because Lord Justice Hamblin, in passing, looking at these provisions, paragraph 41, please, at page 5860. That section 1.1 is focusing on those involved in the doing of the work involved in the provision of the dwelling is borne out by section 1.4, which extends its ambit to developers. They arrange for others to take on work, but do not take on that work themselves. Special provision is therefore needed to ensure that section 1.1 applies to them. And we say that is, first of all, that's obviously right. And secondly, there's no more to be squeezed out of section 1.4, let alone some sort of exception to whom duties are owed under section 1.1a. There's a case relied on by my learned friend in her skeleton called Mirza. Malone Friend did not go to that in her submissions. I can deal with it very shortly. What happened was this. There was a family company called Clay Hall, made arrangements for the rebuilding of the house. The father instructed a builder, Mr. Gilbert, and other trades to perform the work, and the company issued materials. The question was whether the company fell directly into 1.1 as taking on work. Clay Hall, did it take on work directly? Or was it the developer under section 1.4 who is treated as taking on work because in the course of a business arranged to do the work? Now you might wonder, well, why did it matter? Because it was either in 1.4 or it was in 1.1a. But Clay Hall had an ace up its sleeve. Clay Hall's ace was, but the project was a one-off, so I wasn't doing it in the course of a business, and therefore I can't come in within section 1.4, and therefore I don't owe a duty. So the judge agreed that Clay Hall hadn't taken on the work, but he held that it was in the course of a business. So Malone Friend hasn't gone to it, but that's why it isn't relevant. It's not dealing with the question that we're looking at today, and the judge had nothing to say about that question. And so, if your lordships get to that, if the court gets to that point in Malone Friend's skeleton, Mirza is irrelevant. Mischief, part 3. We can close
to keep C out, which are the cases on the DPA.
No, not yet.
I appreciate not yet, but
I'm not.
in the foreseeable future.
I will get to Rendlesham. Yes,
Okay,
yes,
right.
I will get. Sorry, I hadn't understood your lordship's question.
No, that's fine.
So mischief then, part 3. This is my skeleton 86 to 87, and URS 52B and C. Now, ladies and lords, it's common ground that the Law Commission and Parliament identified and debated the issues that purchasers of dwellings frequently had no redress or not reliable redress against those that built them, and enacted accordingly. The background, certainly, there's a consumer element. The Act benefits consumers, that is certainly true, but the Act does not say that only consumers are owed a duty. If we understand URS's case correctly, it boils down to 2 propositions. First of all, that mischief was only concerned with what one might call lay purchasers. Remembering always that purchaser doesn't feature in 1.1a. But never mind, the mischief was only concerned with lay purchasers. And secondly, this court may not stray beyond the mischief when it construes the statute. Now, we've dealt with that in our skeleton at paragraph 86. At subparagraphs 1 to 6. So it's page 20. Well, it's page 21 in my version. A little bit with the references.
Sorry, paragraph.
86.
Thank you.
And we've set out 6 reasons why the analysis that the mischief is only concerned with late purchasers and the suggestion that the court can't stray beyond the mischief. So 1, insofar as the purpose can be gleaned from the wording, the DPA describes itself as an act to impose duties in connection with the provision of dwellings. That's the short title. Doesn't suggest any limit to the class or type of person. No limit is identified in the Law Commission report either. 2, this isn't a case where the words are obscure or ambiguous, so that the court needs to consider the mischief in order to identify their reason, their meaning. And thirdly, the plain meaning is entirely consistent with the mischief and with the purpose of the statute to tackle it. And this is a submission I made a little earlier. It's entirely appropriate that the duty is owed to the developer as well as to the so-called lay purchaser. And no reason has been identified why it would be inappropriate for a developer to be owed a duty. And there are other benefits. Being owed an identical duty ensures that the developer can shoulder the burden of proceedings against those responsible for the defects to the advantage of the people who are living in such a block. We submit that on URS's construction, the result is regressive because, as I indicated earlier, in practical terms, it's rarely feasible for the lay purchasers to take on the big guns. That's paragraph 5. Then finally, in respect of person, any idea that a person can be restricted to a lay person is ruled out by the Interpretation Act. That's subparagraph 6. And the only point we would add is that the same analysis, we go back to the point we made under Benyon, the supremacy, if one can call it that, of the grammatical language. I have included references to the Law Commission report, and indeed I quoted them in our skeleton. I don't go to those now. I simply observe that the Law Commission drew no distinction between lay purchasers and professional developers. It simply referred to either person or client. And there's another observation to be made about the Law Commission report. Again, I don't propose to go to it, but there are no fewer than 16 references to developers in it. So it can't be said the Law Commission was, as it were, back in the misty days of 1970, was unaware of the fact that there were commercial developers and that the language of 1.1a was apt to apply to them. So it comes to this in our submission, that the mere fact that mischief is identified and then addressed in a statute doesn't mean that the statute must be construed in the teeth of its express language as going only so far as the mischief that had been identified earlier. And this court is being asked to imagine not only that the Law Commission forgot about commercial developers, but also that Parliamentary Council and both Houses of Parliament overlooked that a developer could fall within subsection 1.1a. Similar considerations arise under B. There's no suggestion in the Law Commission report that the aim of B is to assist commercial landlords who acquire an interest in a dwelling, but they'd be owed a duty under section 1.1b. Is it going to be said that a commercial landlord isn't owed a duty? How would that happen? Or if that's not URS's position and a commercial landlord is owed a duty, why then should a commercial developer not be owed a duty under section 1.1a? So that's part 3. Part 4, where it's suggested that BDW is not a purchaser of a dwelling. Can I just take a moment to just review my submissions on this? Oh yes. This is dealt with in our skeleton at paragraphs 88 to 91, and in URS's skeleton at 52D. As we understand it, the argument falls into 4 stages, and we've set those out at 88. As to the first 2 of those, the distinction between 1.1 and 1.4 we've dealt with. And as to the 3rd and 4th stages, here we have a supposed distinction between a development on the one hand and a dwelling on the other. What we say about that is that development comprises a number of dwellings and the structural elements and common parts. And if BDW is the party to whose order the development was provided, then necessarily it is also the person to whose order the dwellings were provided. So can I just take the court to Rendlesham? My learned friend, I think, relies on Rendlesham as supporting its position, but on inspection it's the other way around. So Rendlesham is in C again, and it's behind divider 4. Now, the question, if you are provided with a development, can that mean that you are also provided with a dwelling? Was not the question in Rendlesham. But nevertheless, Rendlesham supports BDW's position. So let me take this stages. First of all, if I can turn to paragraph 43, please. Page 3673. With these considerations in mind, it seems to me that Mr. Nisson's argument that the entire building is a dwelling faces insuperable difficulties. If a dwelling is the place where a person or household lives to the exclusion of members of another household, as it seems to me that it must be, then I have difficulty in seeing how the occupiers of, say, apartment 1 can possibly be described as occupying or even sharing the living space that is apartment 2. Apartments 1 and 2 are separate dwellings. In these circumstances, I reject the suggestion that the two blocks, or even one of them, can constitute a dwelling within the meaning of the Act. In reality, each block is a building that contains a number of separate dwellings. But then we come over the page to paragraph 47 under the heading, the meaning of in connection with the provision of a dwelling, where the judge said it is, to my mind, self-evident that an apartment block such as those at Concord Street cannot be built without foundations, a roof, a structural frame, or without suitable access to the various properties in it. Accordingly, it must follow that the structural and common parts of each block represent work that is carried out in connection with the provision of each apartment in the block. And for that simple reason, my own friend's argument does not succeed. Section 1.1, providing that a person taking on work for or in connection with the provision of a dwelling owes a duty. So there's no legs, respectfully, in that argument. So that's part 4. Part 5, BDW has not suffered a recoverable loss. That is my skeleton, paragraphs 92 to 98, and URS skeleton at 52E. I don't propose to read out all of those paragraphs. Again, I would quite sure the court has read paragraphs 92 to 98, and perhaps I can invite it to read them again. What I'd like to do is to look at the cases that we refer to in paragraph 97. May. I'll just read what I say in paragraph 97 of the skeleton. There's no suggestion in the Defective Premises Act that there are limits on the recoverability of loss caused by a breach of the duty. It would appear that Parliament was content to leave that to the courts, applying ordinary legal principles. And then there's Bayumi, Lord Justice Swinton Thomas. There's nothing in my judgment which would indicate that an injured plaintiff is not entitled to recover such damage as he may prove he suffered by reason of the wording of Section 1. And then in Harrison, Mr. Justice Ramsey determined that there was no distinction to be drawn between the approach to damages for breach of contract and that for the DPA. Now, I'm happy to go to those cases if the court would like me to. The passages I've already given reference to, but it may just be worth looking at them as well. So Bayou is a divider 1 of bundle C. The head note, the plaintiff engaged the defendant damp-proofing contractors to prevent damp entering the basement. After the work was done, damp continued to infest the premises. Damages were claimed. County Court judge found that the defendant's work had been defective. This was a cause of continuing damp problems, although it was not the only cause, and held the defendants liable under Section 1 of the Defective Premises Act. Appeal dismissed. Purpose of liability, both the common law and the Defective Premises Act. It was enough for the plaintiff to show that defective workmanship was an operative cause of the damage he has suffered. So in effect there, that's a contractual test, and that's what was applied. And the relevant extract can be found page 195. just where C appears, as was pointed out by Lord Justice Leggett in the course of argument, the short title of the Act is in these terms: an Act to impose duties in connection with the provision of dwellings, otherwise to amend the law of England and Wales as to liability for injury or damage caused to persons through defects in the state of premises. There's nothing in my judgment which would indicate that an injured plaintiff is not entitled to recover such damage as he may prove he suffered by reason of the wording. Section 1, the paragraph in Holsbury, measure of damages is in these terms: the damages recoverable in respect of a breach of statutory duty are such as are contemplated by the statute, and this will include damages which are the natural consequences of the breach. Just to pick up Harrison C3, paragraphs 208 to 212. As the claimant state, those claimants with contractual claims are entitled to damages for breach of contract, Robinson and Harman. 209, the claimants submit that the same rule applies to breach of the 72 Act, so that the claimants are to be put in the position they would have been if the breach had not occurred. That is to say, if the duty had been fulfilled. There's reference to Bayumi, another case, and Heating. Paragraph 211 over the page. By the end of the hearing, SHL accepted that the approach to quantum does not differ, dependent on whether there is a liability for breach of the sales contract, Section 2 of Bill Mark, or Section 1 of the DPA. I'll therefore proceed on the basis which I consider to be correct. There's no distinction to be drawn for the purposes of the three heads of liability. And the risk of stating the obvious, there really ought to be no surprise that where a developer comes along and carries out remedial works, that he ought to be able to recover those under the Defective Premises Act, assuming, in accordance with our submissions, that the developer is owed a duty in the first place by URS. Part 6. My learned friend made submissions yesterday pointing out that in a contract for engineering services there might be a cap on liability, there might be constraints as to when claims can be brought, there may be special provisions about insurance and so on. And my learned friend turned to the statute and pointed to clause 6.3 right at the end of the statute and said, and read it, any term of an agreement which purports to exclude or restrict or has the effect of excluding or restricting the operation of any of the provisions of this Act or any liability arising by virtue of any such provision shall be void. And my own friend complained that if that were to apply to the engineering services contract, that would present all sorts of unexpected consequences so far as those engineers were concerned, and would, to an extent, impact the allocation of risk which had been agreed upon by that contract. The difficulty with that argument from a learned friend is this. First of all, URS had been sued by the owners. If only the owners had been able to fund such claims against URS, then URS would not have had the benefit of any of those limitations in respect of those claims. Second point is that this legislation is dealing with premises which are not fit for habitation. It is hardly surprising, we submit, that liabilities in connection with so serious a state of affairs as that cannot be contracted out of. Precisely the same argument could apply in relation to a building contract. A building contractor says, well, I've got this clause, I've got that clause. These are all very important for me in respect of the building of dwellings in the contract that I have with you as a developer. But again, if the builder, if his failures are so gross as to give rise to a situation where the building isn't fit for where the dwellings are not fit for habitation, the statute provides that nothing in his contract is going to help him. So the same is true of the builder, as it is of the URS's contract. So my learned friend pleads that it's unfair to upset the balance struck in the contract. But the Act says what it says. We don't shrink from it. It means what it says.
I suppose the point is that usually when you have concurrent contractual and tortious duties, you look at the contract to inform the scope and the limit of any duty.
Yes, but this is...
So this would be a completely separate factor that, on the words of 6.3, would potentially have an effect on those obligations. Well, say URS had a cap on liability of 20 million.
Yeah.
Say. Then, according to 6.3, that would go.
Yes.
So that would be, to that extent, Miss Parkin is right to say that's interfering with the contractual arrangements.
Well, it depends what you mean by interfering. I mean, a statute trumps all. The statute has fair and squarely made that provision in section 6.3 for all to see. The statute has been on the books for 51 years. Now, interestingly, one of the questions that my Lord Justice Coulson raised yesterday was, why has this Act not had much legs? Well, the answer to that is the same answer as to why this supposed interference with contractual rights is not as serious as my learned friend makes it out to be. And that is the habitability hurdle. This Act is quite hard to invoke. You've got to be able to show that the dwellings are not fit for habitation. That's why there haven't been so many cases. My Lord, I entirely accept that if there was interference, as so-called, with contractual rights across the board in respect of all defects claims, that wouldn't be acceptable. It would be extraordinary and surprising. But this is constrained to the most serious of cases where the work is so poor, the design is so careless, that you've resulted in a dwelling that's unfit for habitation. That is an extreme case, and an extreme case certainly calls for parties not being able to contract out.
And the courts have made that clear, that the meaning of 1.1, the last part of 1.1, is that it has to be read cumulatively, so that you get to, and so that, as regards that work, the dwelling will be fit for habitation.
The courts have indeed made that clear.
Yeah, so that's why, so your answer to that question is, well, it's a high bar to start with.
Yeah. Only in the most serious of cases.
And your point also is that's what it says. That's what 6.3 says.
Yes.
End of story. And it doesn't matter whether you're a little fish or a big fish.
Yes. Yes. Exactly so. That was part 6. Part 7. Part 7.
Carry on.
At the risk of part 7. Claim time bar. The Building Safety Act doesn't apply to existing proceedings. That's in the URS skeleton at 52F and 39A. It's definitely worth having a note of that because it's in
Sorry, 52F and
52F and 39A,
thank you, no.
learned a friend's skeleton, not in my skeleton because a new point since the skeleton permission. Can we look first at the Building Safety Act, please, which is in core divider C divider 5. Now, at the risk of having too many points, that there are 5 short points to make in relation to this. Section 1353, if we can look at that please, refers to the amendment made to the Limitation Act, as we see in subsection 1, and then says this: the amendment made by subsection 1 in relation to an action by virtue of section 1 of the Defective Premises Act 1972 is to be treated as having always been in force. The observations that we would make on that are that the wording could not be clearer. There is no suggestion that it does not apply to current proceedings as it may apply to future proceedings. It's impossible to understand on that language how it could not apply to current proceedings. Parliament did not say having always been in force, save for current actions. And then there's a few other ways of looking at it in relation to other subsections. So first, if URS was right, you would have expected subsection 6 to be drafted in a different way. Subsection 6 says, nothing in this section applies in relation to a claim which before this section came into force was settled by agreement between the parties or finally determined by a court or arbitration. What one would have expected it to say is nothing in this section applies in relation to a claim or in relation to insert claims commenced before this section came into force, ... and then carrying on. Subsection 5, just above that, says where an action is brought that but for subsection 3 would have been barred by the Limitation Act 1980, a court hearing the action must dismiss it in relation to any defendant if satisfied that it is necessary to do so in order to avoid a breach of that defendant's rights. Now, if learned friend's submissions were correct, subsection 5 would require a distinction between actions brought prior to the Act coming into force and current, and those brought after the Act came into force. And there is no distinction made there in that respect either. And working our way back again, subsection 4 says this. This is the initial period. In a case where, by virtue of section 1, a person became entitled before the day on which the section came into force to bring an action, and the period of 30 years from the date on which the right accrued expires in the initial period. The initial period is 1 year after the Act coming into force, so you get an extra year. Section 4B, in other words, the provision inserted, has effect as if it provided that the action may not be brought after the end of the initial period. So that can only encompass claims that would have been time barred when the Act came into force, because it's only buildings that were built around about 1992 for which the 30-year period would expire in the year after the Act came into force. And then you get this paradox. If you had already started proceedings on a learned friend's case, you wouldn't get the benefit of section 1354. But if you hadn't, you would. And that can't be right. So those are what we might call analytical points in relation to the language. But also, there's a much...
Just before you move on, could I one other analytical point that
Yeah.
struck me is Miss Carlton very firmly referred to the repeal, and in order that she could then track across to the Interpretation Act. But am I right in thinking that 3 refers to it as an amendment as opposed to repeal?
Yes.
So is that, so
Well,
would
then-
your submission be that therefore you can't call it a repeal in order to track it into the Interpretation Act?
Well, my learned friend, well, I'll come on to the Interpretation Act and I'll think about my lady's point, if I may, a little further. What my learned friend said was an implied repeal. And so I'll take on board my lady's question and I'll think about what the answer is. So thank you for that question. The bigger point that I was about to make is that it would be absurd if merely because one had a running action under the Defective Premises Act not to be able to have the benefit of the change made by this Act. That's the big point in all of this. Now, in my learned friend's skeleton, paragraph 39A, she refers to a whole series of authorities. Forgive me. A is at page 21. She refers to Wilson, Moon, Reed, Heston, Eubon, and the Interpretation Act. You'll be relieved to hear that I'm not going to go through all of those cases. The point is this, that all of those authorities recognise that Parliament may make retrospective legislation and legislation which applies to, in effect, existing as well as future proceedings. So there's no doubt that Parliament can do it. In that respect, in our respectful submission, is what they've obviously done here, because there is no reason offered and no sensible reason why someone with an ongoing action should not have the benefit of the Act. The other point about all of those authorities is that none of them helps with the language that has been used in this Act, because in none of those cases did the wording compel the outcome that the retrospective legislation, admittedly now retrospective legislation, impacted current proceedings. That the wording didn't compel it, so the court said, well, then the wording doesn't compel it. And in each case, when one looks at them, there are perfectly rational reasons why the court would arrive at that conclusion. Now, but can we go to Kadir, which is in the first core bundle, which does provide some assistance with the impact, if I can call it that, of such wording in a new statute. And as I say, it's behind divider 15 in core bundle 1, Secretary of State for the Home Department in the case of Kadir. Now, it is probably worth me just outlining the facts to the court, because otherwise it can be quite hard going, so I hope it will help. Here in this country, an asylum seeker can be granted temporary admission or exceptional leave to enter. It may be that the court's very familiar with this case. The ELE, the exceptional leave to enter, is much better for asylum seekers than is temporary admission. Mr. Kadir had the status of temporary admission for a long time, and by various routes was looking to be granted ELE. Mr. Justice Crane concluded the temporary admission was no longer lawful and ordered the Secretary of State to give further consideration to exceptional leave to enter, ELE. Then, Section 67 of the relevant statute was enacted with retrospective effect, so as to put beyond doubt that which the Secretary of State had always assumed was already the law, namely that for someone in Mr. Kadir's position, the extension of temporary admission was lawful, didn't have to grant ELE. Now, the Court of Appeal upheld the decision of Mr. Justice Crane that the continued temporary admission was unlawful, but held that Section 67, retrospectively enacted as it was, meant that Mr. Justice Crane's decision could not be upheld. The House of Lords determined that both Mr. Justice Crane and the Court of Appeal were incorrect as to temporary admission. It was, and indeed had always been, the law that the extension of temporary admission was lawful, with or without Section 67, and so it had been unnecessary to enact Section 67 in the first place. For that reason, the House of Lords didn't need to consider the Court of Appeal's examination of the question of retrospectivity. And the order, therefore, in the end, was that the Court of Appeal's decision was upheld on different grounds. So, with that, I hope helpful introduction to the facts. I only want to take the court to the passages dealing with retrospectivity. So, starting, please, at paragraph 23. This is in the judgment of Justice Kennedy. In paragraph 23, the relevant act, which is the Immigration and Asylum Act, was set out, section 67, and for these purposes we only need to go down to subsection 3. This section should be treated as always having had effect. And then 26, the next question is whether section 67 applies to an appeal from a decision taken before the 2002 Act was passed. As to that miscast risk, invites our attention to page 269 of Benjamin, which states that where an amending enactment is intended to be retrospective, it will apply to pending actions, including appeals from decisions taken before the passing of an Amendment Act. Paragraph 32, if I may. Turning to the 2002 Act, Mr. Blake submits that section 67(3) should be construed in such a way as not to impact upon this appeal. He recognises that the statutory wording is clear and would now apply to any decision at first instance, but he relies upon CPR 5211 to show that at least initially our function is limited to a review. So there was a debate then about the distinction between a rehearing and a review, but it's notable because Mr. Blake recognises the statutory wording is clear. And then moving on to conclusion, at least so far as Lord Justice Kennedy is concerned, paragraph 39. In my judgment, the decision of Mr. Justice Crane was correct at the time when his judgment was delivered. Moving to paragraph 40, but that situation was changed by the 2002 Act. The wording of section 67(3) makes it clear beyond argument that the whole section must be treated as always having had effect. And then in the judgment of Lord Justice Chadwick, if I may, please return to paragraph 55. Is this court required to hold that the decision under appeal cannot stand, having regard to the change in law effected subsequently by the enactment of section 67? But for section 67(3), I would have no doubt that the answer to that question should be no. But section 67(3) of the Act requires that this section shall be treated as always having had effect. That, as it seems to me, is an unequivocal direction to which this court must have regard. The direction requires this court to determine this appeal on the basis that, for the purposes of the 71 Act, the claimant was a person liable to detention, and so on and so forth. It follows that the judge's decision cannot stand. And then 58, right in the middle of the paragraph. Parliament has made clear its intention that temporary admission under paragraph 21 of the 71 Act should be available while and for so long as arrangements following a decision to remove are impeded or delayed by practical difficulties. And then 59, after 5 lines, where Parliament, after addressing its mind to the problem posed by the difficulty of holding consistent with those cases that removal is pending, in a case where it cannot be said the practical difficulties are short term, has enacted that, in such a case, temporary admission is an available option, I find it impossible to say that it's irrational for the Secretary of State to take that option. Paragraph 60, 3 lines in, further having regard to the retrospective effect which subsection 3 requires, seems to me impossible to hold that if the Secretary of State could now make that decision, it can be treated as flawed at the same time, at the time when he did make it. The fiction to which section 67.3 requires the court to give effect is that the law was, in May 2002, as it now is. I conclude that the order cannot stand. And Lord Justice Mance, as he then was, to the same effect. The references, please, are to paragraph 92, which I won't read out, it's to the same effect, and paragraph 93. So, in our respectful submission, that was indistinguishable wording in the statute. That was an ongoing and current action. Indeed, the legislation had been enacted in response to the first instance judgment of Mr. Justice Crane. There were no, it wasn't written down in subsection 3, oh, by the way, when we say that this piece of legislation is retrospective, it does apply to current ongoing claims as well. Our submission is this, that where you have words as powerful as those words and as powerful as section 1353 in a statute, it obviously applies to current ongoing claims, particularly in circumstances where there is no good reason why it should not. And Parliament thought about that question, and in section 1356 it said what you can't have is the benefit of this act if you've already brought a claim and there's been a judgment and or there's been a settlement. It didn't say you can't have the benefit of this retrospective section if neither of those two things applies. Well, that concludes my submissions under the Defective Premises Act. I anticipate being, I should say that the Contribution Act notoriously is difficult. It will take me a little time to go through. I can't imagine it's going to take me longer than an hour and tops an hour and a half, but it's a difficult act to construe, and I propose to give as much assistance as I can.
Thank you.
I'm in the court's hands as to whether the court would like me to make a start now, or whether that is a convenient moment to break.
No, I think it's a logical place to finish today.
Thank you.
Anything else? Any questions out of this part? Out of this round? No. Very well. Thank you all very much. 1:30, please.